Hello, welcome to Evidence Law, Week 3, Part 1, Relevance. It's me, Jason. I wanted to re-record this one because I was listening to the audio of the last one and it wasn't the best. It went a bit long, so I'm going to give it another shot. To catch you up very quickly, last week we talked about the somewhat procedural and technical rules surrounding adducing evidence, making sure it's presented in the correct form. For the next few weeks, we're going to be talking about admissibility rules. Starting with relevance, is the evidence logically relevant? And despite that being true, and despite it likely being then useful for the court, is there still a reason to exclude it, either based on concerns about factual accuracy, misleading the trier of fact, fairness, things like that. So today's relevance, then exclusionary rules, and in the last class we'll talk about proof one more time, instructions given to the fact finder about how to weigh up the evidence that we've now determined is admissible, not subject to an exclusionary rule. Relevance, I think, is and many people agree, is the most important, most basic, most foundational evidence rule. In one of the recommended readings, Justice Gagler says it's the basic rule of admissibility. And we can see that in Section 56. It determines what is prima facie admissible or what is inadmissible, and places the burden on the party who is adducing the evidence to demonstrate that it is relevant on a balance of probabilities, Section 142, sub 1. Now, the other reason I think we need to understand relevance is that it helps us determine the application of other rules. So when that party who bears the burden of explaining the relevance of this evidence, to demonstrate the relevance of this evidence, in doing that, they have to explain how this evidence is going to be used. If it's what is the relevant use of the evidence? We'll talk about this quite a bit with the hearsay rule. And because they bear that burden, they might have to say that it is relevant but admissible for some use that might engage an exclusionary rule. I'll talk about that at the end, but that is another reason why you should consider relevance first and perhaps consider it the most important rule. As you're considering facts, I think you want to think about relevance first. So that is why this one is pretty short, and I'm going to swing it over to Salim to finish up this week, talk about hearsay. So let's start with the statute, the letter of the law. Section 56, as I just mentioned, says that relevant evidence to be admissible. Subsection 1, except as otherwise provided by this act, evidence that is relevant in a proceeding is admissible. So subject to other rules, prima facie, relevant evidence is admissible, and evidence that is not relevant is not admissible. This sets the stage for everything that's to come. And what does relevance mean? We talked about this a bit in the tutorial for week 1, but relevant evidence seems to be evidence that could rationally, logically, directly or indirectly, so directly or circumstantially, affect the probability that some fact and issue exists. If you recall, we juxtapose that with the notion of probative value, which seems to be the degree of relevance. And we'll talk a lot about probative value when we get to my discretions class and what I believe is lecture week 8. Courts can deem evidence provisionally relevant. So this would be the situation in which we don't know this evidence is relevant until we see other evidence. So the example that I give is it might be relevant that the accused was having coffee at the cafe near the bank that was robbed. But if there is no admissible evidence that a bank was robbed to begin with, then that wouldn't be relevant. But we can call it provisionally relevant until we see the rest of the evidence. And also, as David talked about last week, evidence can be the court can make inferences as to the relevance of evidence. We talked about this in the context of authentication, suggesting that the common law requirement of authenticating the document, proving that it is what it actually is, or what the party purports that it is not actually a requirement anymore, because the judge can draw a reasonable inference that it is authentic, thus leaving that as an issue that goes to the weight of the evidence for the finder of fact. So I think there's a useful distinction to be drawn, and one that I think we're going to see in both of the cases we look at, some members of the High Court struggling with to some extent. So sometimes in the common law and some legal writing, and we'll see this discussed right now in the Australia Law Reform Commission report about that preceded the Uniform Evidence Law. There's a distinction drawn between logical relevance, which I think we see embodied in Section 55, and this notion of legal relevance. Legal relevance is sometimes considered to be evidence that has low probative value, so it's not very relevant and has some prejudice attached to it, and is therefore not legally relevant. It's a bit of the term legal relevance, I think, is not the best, because you would think that Section 55 should be about legal relevance because it's the law and it's the law and relevance. So a bit misleading terminology. I think Section 55 is better characterized as a logical relevance provision. But if you want a little discussion on legal relevance, you can see that in the Law Reform Commission report, which went through several different relevance rules that they were considering before landing on the one that they eventually chose, which is embodied in Section 55. You can read this. I've uploaded this slide. But the Law Reform Commission says there is this notion of legal relevance, which suggests that evidence can be deemed relevant if not that it has zero probative value, but it must have sort of some minimal threshold amount to be relevant. So something perhaps above zero, sort of depending on the case. And they ultimately rejected this. They say the concept of legal relevance provides no assistance to a trial judge in performing his task, giving no idea of the factors which may be legitimately considered imbalanced. Indeed, it positively misleads him into oversimplifying the task he is confronted with. The two issues should be distinguished: relevance and discretionary exclusion. So that's what we have. What we have now is a rule that says evidence is relevant if it just has a logical bearing on a fact and issue, but it still may be excluded, as we'll talk about, if it has low probative value or its probative value is exceeded by its unfair prejudice as a discretionary exclusion. And so I think we see that seems to be the rule that was adopted, or like it was the rule that was adopted. But I think there's an argument that some high court judges actually think or seem to be employing a legal relevance test, as we'll see. So again, that's just a rule to remind you. The first case we'll look at is Smith and the Queen, 2001 High Court case. Interesting case. So it's a bank robbery, and the identity of the robber is at issue. So we typically identify the facts and issue first. And there is some photographs that were extracted from some CCTV footage of this robber. And that's available for the court to view and compare to Smith to say that they think it's the same person. But there are also these two police officers who have had previous dealings with Smith, a bit of a local ne'er-do-well. And important to note that this is not the typical situation that you would normally think of in which the police were at the scene of the crime or the putative crime and observed somebody that looked like Smith. These were not eyewitnesses. It's a bit of a different situation. To draw this out, they are just two people who have some added familiarity with Smith. They're looking at the CCTV footage. They're looking at Smith and they say, oh yeah, we've dealt with him before. This is the same person. And we can help you, court, because we have seen Smith more than you have. We've seen him in other contexts. We've seen him outside of court. So we're better at looking at this photograph than you and determining if it's the same person or not. And that's different, as I've drawn out here, than the situation in which the police officer was actually at the crime scene and said, "Oh, yeah, I was there. And I saw Smith. He's someone I know. I can tell you very clearly he's the man here in court with us." It's not what happened, and that's the relevance problem. As we'll see, the court here, as you can read, says the issue here is identity. We've got to figure out how this is relevant to identity. And the majority says this type of identification is not relevant. The assertion of identity was founded on material no different from the material available to the jury from its own observation. So saying the fact finder can make this comparison itself. There's no need to have any assistance. It has the very same material in front of it. Smith, CCTV footage, it can make that comparison itself. This process is neither assisted nor hindered by knowing that some other person has come to some conclusion. They might contrast this to other circumstances. For instance, if there was someone who purported to be an expert in face identification and have a ability to do that at a high degree of accuracy, higher than the public, then that might seem to be relevant, but this is not what's argued here. This is someone who has who's in a very similar perspective to the jury. Justice Kirby disagreed, said, "Oh yeah, it's relevant because the Uniform Evidence Law established a low bar here," and that doesn't end the analysis. It's relevant, but there's an exclusionary rule that would apply, opinion evidence rule, and we'll talk about that in a few weeks. Next decision we'll look at, the last decision we'll look at for today, for me, is the High Court in Evans. This is a case that you talked about a bit with David last week, in the context of, was this demonstration of putting the accused in a balaclava, overalls, having him say, "Give me the sheriff's money," because he apparently had a certain affectation to his speech pattern. Was that a view pursuant to Section 53, and therefore certain procedures had to be followed? The court said no, and it's not regulated by that. The little bit I do is that I think serious sounds like the way Sean Connery would say serious, because he always puts a SH in front of things. I think because his name is S with no H next to it, but it sounds like sh, so he says everything like that. Give me the sheriff's money. I have a license to kill. Anyhow, this is the part I should cut out. The issue beyond was the proper procedure followed Another issue was, is this relevant to begin with? Does this actually tell us anything that the jury can't mentally simulate on their own? And the accused says, "No, this is just a Smith situation. The jury can look at the balaclava, look at the overalls, imagine him saying serious. Doing this adds nothing to their fact-finding process. This is not relevant," as we'll see. And there's another argument that it's just simply unfair to overly prejudicial. It will interfere with the fact-finding process to take the accused person, dress him up in the outfit of a robber, and say essentially stick it up, stick to the jury. That is something that will create an image of a robber in the jury's mind, and they won't be able to cast it aside and think logically about the case. So let's just run through the judgments. There's basically 3 of them. The first one, I would say that the first one in Kirby's, I would find to be the most coherent. The middle one, I have a hard time understanding. The first one, authored by Justice Crennan and disgraced Justice Hayden, say the balaclava is relevant because he might look like the descriptions from the witnesses. If he's wearing this is something that will assist the jury. However, and also the unusual pronunciation, not everyone talks like that. So it seems like if he ends up being someone who has that affectation, that gives us a little more evidence that he might be the person. Similarly, putting on the overalls, it might look very baggy. One of the witnesses said it was sort of, he was wearing clothes that were overly baggy. So if that's the fit, then that adds a little bit of probative value. If it doesn't, that also tells us something. Also, the way he walks might be useful to see if it matches the other evidence. So they say it's all relevant. The decision of Justice Gummo and Hain, I find to be a challenging one to understand. They say that the clothes are irrelevant. Dressing the appellant and the items provided no information that the jury could rationally affect directly or indirectly, to the jury that could rationally affect the determination of the fact and issue. Nothing more than they could glean from observing him and the clothes. So this is hard to understand because I think sometimes that I can look at clothes and look at myself and think it's going to fit well and ends up not fitting well. It's not something that I think I can mentally simulate as well, but Gummo and Hain think so. And they say, however, the walking and talking, that's something that the jury can't mentally simulate. That they'll need help with. So that is relevant. Kirby says everything's relevant. However, it's overly prejudicial. As we'll talk about in a few weeks, he would exclude it under Section 137. From the final paragraph, even if glanced at for a moment, such an image, like images of hijackers, terrorists, murders in well-remembered films, documentaries, and news broadcasts, would etch an eidetic imprint on the jury's collective mind. It is an image unfairly prejudicial to the appellant. I find that convincing. So, final sum up on this. Most of the judges say it's relevant. 2 of them draw a distinction. Seems like they're doing some sort of more legal relevance thing that was rejected, but that's the decision that we get. So just as the final little bit I'll say that I think will transition into the final part of this week relevance is that, as I mentioned before, in this exercise in determining the relevance of evidence, you will sometimes find that there will be multiple different ways in which it's relevant. It'll be relevant for different uses. And some of those might engage a exclusionary rule that you'll have to keep in mind. So the example I give here is that maybe you want to call a witness that will say that he overheard somebody else and talking to the accused, and they were saying that they were in Bali the night that a robbery occurred in Sydney. So here, just from a starting point, it seems like the relevance is, if that's true, that's accepted, then the accused did not have, this is exculpatory, the accused did not have the opportunity to commit the crime that was in Sydney, that was in a different place. But that, as we'll talk about in a second, that depends on that statement about them being in Bali being true. Because if it's false, then it's irrelevant, right? It depends on them, like where they actually are, if they actually were there. So the relevance there seems to be tied up in the truth of the statement. However, you might think that there are other situations. So perhaps the accused is going to give evidence, and he's going to say, "Oh, I was in Newtown that day. I was across town in Newtown." Contradicts what Bob says. However, now that the relevance of what Bob said is there's another source of relevance. There's another relevant use, and that's to demonstrate that the accused seems to be saying inconsistent things. And for that use, it doesn't really matter which one is true. It just matters that he's said two inconsistent things. He said he was in Bali, and he said he was in Newtown. That doesn't depend on the truth value of the statement. It's just a mere inconsistency. So now we have two different uses. One that depends on the truth, one that doesn't depend on the truth. Does that change the way in which these rules are engaged and enforced? Maybe we'll see that in a few moments with Celine. But just to sum up, relevance is the probably most fundamental admissibility rule. The rule as written and I think as intended seems to be one of logical relevance, although the actual interpretation of that by some high court judges seems to be a bit more nuanced, maybe more somewhat colored by this idea of legal relevance. And as I just mentioned, I think it sets the stage, as we'll do now, for some other